Former President Jacob Zuma has instituted a private prosecution bid in the Johannesburg High Court targeted at President Cyril Ramaphosa. It's a bid which Ramaphosa has rejected. For a legal perspective on the matter, we are joined by legal analyst Mpumelelo Zikalala. Mpumelelo, good afternoon to you and welcome as always. Before we get to the law, let's talk about what was an interesting exchange between Zuma and Ramaphosa at the start of the conference yesterday. We'll have a look at this video.
Oh yes. I'm growing young. You guys are growing old and big.
I mean, you'd never say there was a problem there, because shortly after Zuma makes his dramatic entrance, after Ramaphosa has already begun his political report, followed by his supporters chanting in what seemed to be a carefully choreographed entrance, what do these two very different pictures convey to you?
You know, in Zulu, there's a very famous saying that says, which means that you may laugh together and be happy and be jolly. However, behind us, we are carrying very dangerous weapons that you intend to use against one another. So I think that's exactly what was happening in the case when there are summons that have been served at your residence, calling you to go into court on the 23rd of January and go and defend yourself on allegations in which you have timelessly and up until now issued a deadline of saying, if you don't withdraw them, I'm going to take further action. So that's definitely what was happening yesterday.
I mean, what is stark and seemingly treacherous about this is the wording in the State Attorney's letter to Zuma's legal team in response to their private prosecution, that it's common knowledge that the president will stand for re-election as presidential candidate. It is common knowledge that the purported summons was served to halt his candidature. So given that this view is without a doubt Ramaphosa's view, how much more insidious does it make that show of comradeship?
It does sort of cast a doubt as to whether do they really understand what they're supposed to do. But what is of concern to me, don't use state machinery to fight your own political battles. So I would have expected that letter to then say, let's look at the legal merits of the matter. I don't want to look about anything else. I have nothing to do as a state attorney with ANC elections or any other political parties' elections. I have nothing to do with other factional battles which are taking place. All that I intend to do as the person who is defending the president is to look at the matters as they are, because at the end of the day, I'm protecting the office of the presidency, not the man in the office. If the man in the office wants to protect himself and his right, he should instruct his own attorney to write a letter in that similar fashion, contain those particular words so that it is easier to see that now I'm responding or I'm dealing with the legal representatives of the president or of Mr. Ramaphosa and not of the office of the president of South Africa. So those things must have been distinct in terms of being labeled as such, because you do not want to create a very bad precedent of blurring the lines. You don't want to create a precedent of where things are sort of blurred. You don't even know whether the state attorney is defending the office of the president or is defending the president of the ANC.
And that's an interesting choice of words you use there. Was exactly what I was going to ask as well, this blurring of the lines. Ramaphosa now giving Zuma until Monday to withdraw the private prosecution against him. What does he have at his disposal to arrest any further legal steps by Zuma? And what is open to him should that not happen?
Unfortunately, other than trying to bring the matter forward in terms of the date that has been set by the courts, there's really nothing that he can do. You see, the courts are open for every type of disagreement or dispute to take place. What matters the most is that when you get to court, are there any merits in what you're bringing to court? And what is the law going to say? Most importantly, what is the law which is going to apply by the presiding officer, which is who is going to be looking over your matter? So sending a letter like that, it is simply, for lack of a better word, a scare tactic on someone who is hell-bent of making sure that on January, someone or the president must go to court and be able to appear. If all the other legal instruments that enable or call upon an individual to go and attend court have been complied with, then definitely the president has no choice than to go to court on that day. Anything else is going to be in tantamount to ignoring a directive that has been issued by our court rules, and there are repercussions for this, including the issuing of a warrant of arrest. So anyone can open a case, anyone can go to court and get a case number and call any individual to come and display or maybe defend themselves in court. What matters the most is that what is going to happen once you enter the courtroom. So the attempt by the state attorney to then write this letter to simply say, Mr. Zuma, I'm trying to warn you here. I'm going to take very legal steps when the time comes, which you can only come in January, in order to defend myself. But I want, when I even institute civil action, to be clear that You are misusing or misrepresenting what the law actually says. It was the abuse of processes that have been given to you. And in fact, I'm going to use as part of my argument at a later stage when I say that this matter must be dismissed.
There are some nuances I want to get to in just a moment, but let's take a view of what the ANC's electoral committee is saying in terms of making the separation in this matter. You know, the difference that this is an irrelevant summons, not applicable during the vetting process of the ANC, because these are not criminal charges in a court of law. And it goes on to explain other details. But what do you make of their perspective on how they frame it for themselves? And of course, it speaks to the legitimacy and the eligibility of the president of the ANC to, return and contest for this position.
I think they should have framed it a bit better in terms of their response. You don't know where they're trying to get to in terms of saying we're not going to entertain this particular matter now. I think a better answer would have said, this matter is coming at a point in time in which we've finished our vetting process. Everything has been done. If anything that has to be considered by the Integrity Commission, they can go ahead, but it will have to wait up until we are done and dusted with this particular conference. We can only deal with instances and sequence of events that have taken place during the conference, pertaining to the conference, that has the potential of harming the legitimacy of any candidate which is going to stand and be able to stand for a particular position. And the second one then defend yourself by saying we are only going to entertain matters where a person has appeared in court and they've pleaded in court and they've been given bail or been charged at the end of the day. Now, the issuing of summons, yes, you may say from the NPA side, you are charged, so yes, so may be. However, the final nail in the coffin in terms of your charges then has to be issued by the court when you appear in court for the very first time. Because that's when in which you are going to hear those charges formally being placed upon you. That's when you're going to hear certain bail conditions being issued against you. That's when you're going to hear that I'm really now considered as an accused. You can't be considered as an accused by the mere issuing of summons, especially when it comes to private prosecution and where there are certain elements that may be missing.
Yeah, I mean, but look, you see what the intention is in terms of making sure that, unlike others who have been charged, his eligibility is not in question. Let's go back, though, to the merits of the course Zuma is taking, accusing Ramaphosa of being an accessory after the fact and crimes committed by, amongst others, Advocate Billy Downer in respect of his medical information. Explain this to our viewers and whether his position has strong legal legs.
Yes, it does. Let's look at the Criminal Procedure Act, which then governs how prosecutions are supposed to take place. There's a very distinct defense that you can use, which has been used by the former president in the Downer case, in which you then say, in terms of Section 106, you don't have charging to prosecute me. The charging that you claim to have claimed or received as a private prosecutor is not a valid one. Why? Because it was given to you in a blanket approach. Now, our courts or our law is very specific in terms of saying whenever the NPA is going to assess the merits of the matter, it looks at the person in which you are supposed to, or the suspect, and then look at the merits of the sequence of events or the evidence that it has, and checks whether it can be able to get enough evidence which is going to guarantee a conviction at the end of the day. A conviction being the evidence of the sequence of events that you are going to deliver or state in court must be so convincing that there's no other argument that is there that can dispute what you are saying. Hence, you are guilty beyond any reasonable doubt. Now, in this case, the evidence of the NPA only looked at Advocate Billy Downer's merits and said, we are going to look at the role and activities which have been played by Advocate Billy Downer. Unless if the president can then come and say, or the former president can then come and say, when you did your assessment, you also look at the merits against the current president. And when you issued your certificate with no suspect identified, I was of the assumption that you included everyone that was in the docket or part of the representation that I've made earlier. So in fact, it is not my mistake that you've issued me a blank prosecution certificate, or a one-for-all type of certificate that I can use it on anyone, that I can be able to prosecute that particular individual. I have not done that myself because I did not self-issue that particular certificate. It was issued by the NPA. So on that basis, don't blame me for that particular blunder. I must blame the NPA. But from the defense of the president, will then come back and say, show me the records in which the NPA then had a careful assessment of what they were doing, and show me the fact, where do I enter in this whole frame? But in addition to my defense, let's look at my role as the president of this country. There's the Minister of Defense who is below me that has to take care of this particular matter before it gets to me. But most importantly, it is the NPA which is independent and ought to be independent. It has not taken a decision pertaining to me as a suspect. Hence, you may have a paper which is written down saying that you have a charge to prosecute. However, the merits of that particular charge to prosecute cannot be true because there are certain elements that are missing. The unfortunate part, or when all this particular process will be settled, it is when they go into a court of law, unless the former president decides to withdraw those particular summons.
Well, you've left us precisely nowhere, thank you very much, Mpumelelo, because you've presented both those arguments. And I guess the public wants to know, given, the questions and the controversy around the validity of that legal certificate, is it valid? Does it cover Zuma more than it covers Ramaphosa's rebuttal to that or response to that?
I think it should cover Mr. Ramaphosa more, because then you have to say, what sort of specific assessment did you make against Mr. Ramaphosa? In terms of his role and involvement in this particular matter, where does it leave him? What wrong has he done? That's the most important question. On that basis, what sort of evidence do you have? And on that particular evidence being so minimal that the NPA then so decide that you are not going to prosecute on this evidence because there's very little that you can work with. So Mr. Zuma can go and prosecute the president, it's fine. But in this case, it seems as if the assessment which was done when it comes to private prosecution was only directed to Advocate Down, unless there's something else that has taken place and has tended to be corrected on that one. But on this one, I think the merits favor Mr. Ramaphosa on this one, because they'll come back and say, on a technical basis, on the true intention of what the certificate of prosecution actually means, you do not have a leg to stand on. But most importantly, you are accusing me of doing something that I'm not even supposed to do as per the law. So I can't break the law so that you are able to satisfy yourself. At the end of the day, I do not meddle in the matters of the NPA. They only account to the minister and to parliament. When it comes to me, I only ensure that the appointments are being done. Anything else, there are relevant laws that can be able to take care of that.
I guess we'll see which way the tree falls in the days ahead. Legal analyst Mpumelelo Zikalala, thank you very much for sharing with us your perspective and your legal view. Appreciate it.